Let's be absolutely clear here. The U.S. Department of Justice is bringing its prosecution against Southern Poverty Law Center in bad faith. Not because nothing happened there, something clearly did, but because of how the government is choosing to frame it and which charges it's leaning into most heavily. Hi, I'm Nate Charles, and welcome back to the Rule of Law Brief. If you actually read the indictment against Southern Poverty Law Center, strip away the rhetoric and just focus on what it actually says, a very different picture emerges from the one that you're probably hearing in the news, and definitely different from what you're hearing from conservative talking heads. The indictment alleges that the Southern Poverty Law Center was using paid informants, what it called field sources, and that those payments were made clandestinely. It also makes it clear that these individuals were embedded inside the very extremist organizations the SPLC was targeting, and that funds were routed through layered transactions and intermediary entities to protect the operation and the sources involved. That's not speculation. That's the government's own description of what occurred. And when you translate that into operational terms, what you're looking at is straightforward. They were running sources. They were using human intelligence tradecraft. Now, the government doesn't present it that way. Instead, the Justice Department is leaning heavily into this much more inflammatory narrative that the SPLC was somehow funding hate groups. To be clear, that is demonstrably false. It is a serious distortion. Paying individuals inside an organization to provide intelligence is not the same thing as funding the organization. What it does constitute is infiltration, penetration. And that is how you actually dismantle networks from the inside. And that distinction matters because the entire fraud case rises and falls on whether donors were misled in a material way. Not just whether something wasn't disclosed, but whether a reasonable donor would actually care about how these funds were being used. So let's ask the real question. Would a reasonable donor to the Southern Poverty Law Center be troubled by this? And the answer is clearly no. Because when you dig into the details, you'll learn that the organization wasn't just publishing reports or filing lawsuits, but it was actually embedding sources, gathering intelligence, and trying to dismantle extremist organizations from within. For the vast majority of donors, especially those inclined to support that mission, that's not disqualifying. If anything, it's impressive. It reflects a level of operational sophistication that goes far beyond surface level advocacy. Speaking for myself, reading this indictment doesn't make me hesitate to donate to Southern Poverty Law Center. If anything, it makes me more inclined to support that kind of work. And if that's even arguably how a reasonable donor would act, then the fraud theory has a serious problem. Because without materiality, there's no fraud. And once the fraud counts fail, the money laundering counts fall with them. That's not a policy argument, that's black letter law. Money laundering requires the proceeds of a specified unlawful activity, an SUA. Here, the only alleged predicate is wire fraud. So if there is no fraud, there are no unlawful proceeds. And if there are no unlawful proceeds of an SUA, then there is no money laundering. That entire count collapses as a matter of law. So the most serious charges in this indictment, the ones getting all the headlines right now, are built on a very unstable foundation. And they will almost certainly fail if this case goes to trial. But here's where we need to be honest, because acknowledging that DOJ is bringing this case in bad faith doesn't mean that there is no legal exposure for the Southern Poverty Law Center here. There's another set of charges in this indictment that are very different in character. False statements to banks. The government alleges that the SPLC opened certain accounts under fictitious entity names and that representations were made about the ownership of those accounts and the control of those accounts that was not accurate. Now, those charges do not depend on donor expectations. They don't depend on narrative framing. They turn on a much narrower question. Were the statements made to the banks true or false? And that's where the comparison to law enforcement tradecraft becomes unavoidable. Because everything described here looks exactly like standard undercover human intelligence tradecraft. The FBI and the CIA do this all the time. They pay informants. They embed sources inside targeted organizations. They set up shell corporations. They set up dummy accounts. They structure payments to protect those sources, and they use non-attributable financial mechanisms in order to funnel money to clandestine sources and protect the nature of those transactions. They can even authorize what's called otherwise illegal activity, conduct that would normally violate the law when it's necessary to carry out an investigation. I know this from personal experience when I worked in the counterintelligence section of the U.S. Department of Justice. I've been personally involved in this. But the key difference is authority. The FBI and the CIA are allowed to do that. Private companies, regardless of their mission, aren't. Law enforcement can do those things because they are operating under the public authority doctrine with formal authorization and internal oversight. A private organization does not have that protection. So even if the underlying strategy looks the same, the legal footing is completely different. And that's why this case looks the way that it does. The headline charges, fraud and money laundering, are broad, dramatic, and very vulnerable, almost entirely frivolous, frankly. But the narrower charges, the false statements to banks, are technical, specific, and much harder to dismiss. And that plays into the Trump administration's narrative. That asymmetry is what gives this prosecution its bad faith feel. The most serious charges here are playing into the Trump administration's narrative. They will not hold up. But there are charges in this indictment that will probably actually stick. They are far more limited and much less sensational, but they will ensure that something sticks against the Southern Poverty Law Center, which again feeds the Trump administration's narrative. What you have is a situation in which you can hold two ideas in your head at the same time without any contradiction. First is that this prosecution is being brought in bad faith and to feed a narrative that Donald Trump wants to infect the rest of the world with. And the second is that the Southern Poverty Law Center probably still did cross a legal line when it comes to how certain financial accounts were structured. Because unlike the FBI, it does not have public authority to engage in otherwise illegal activity, even in service of an objectively noble mission. But those are very different claims from each other. And collapsing them into a single narrative, turning infiltration into funding hate groups, is exactly what makes this indictment so problematic. At the end of the day, the most serious accusations are probably going to fall apart. But simultaneously, at the end of the day, the Trump administration is likely to sustain at least some of the charges in this indictment, which is just going to add gasoline to the fire of their narrative. The bottom line here is that the Southern Poverty Law Center was in no way funding hate groups. They were paying people of low character within those organizations to rat on their friends. And it worked. The problem is that that nuanced narrative is almost certainly going to get lost in the inflammatory headlines about things that the Southern Poverty Law Center did that probably actually were illegal. If anything, this is just a data point for how sophisticated the Trump administration is at lying to the American people.